very much for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. And today we are going to talk about the national interest waiver. And I'm the founder of the firm, and we did have another attorney that was going to do the presentation, but she got called away to do something else. So I am here in her place. But I have just as much expertise with respect to national interest waivers, so we will be able to run through the presentation and answer any questions that you have. The Scott Legal is a full-service immigration law firm. We do a number of different visa types, including national interest waiver green cards. And a few housekeeping items before we jump into the presentation. One, we are going to send you a number of things after the presentation. The first is we're going to send you a copy of this PowerPoint that you see on the screen. The second is we're going to send you a link where you can set up a consultation. The third thing we're going to send you is this webinar is actually going to be recorded. So we will post this on our YouTube page, and we will send you a link for that. And we do encourage you to subscribe to our YouTube channel so that you can get a number of different webinars and other video updates that we post there. We do hold webinars a couple times a week on a number of different immigration topics. So definitely good to subscribe. And then the final thing that we're going to send you is a national interest waiver guide. So that is a guide that in essence has all of the information that we're going to go through today in a bit more detail. So you'll have that handy for reference. So without further ado, let us jump into the national interest waiver requirements. So, and then the final thing is if you do have questions, please feel free to add them to the chat or the Q&A function in the webinar, and we will get to all questions. So the first thing that we're going to look at for national interest waiver is really the threshold requirement. And this is something that is very important, and I think it's something that's often misunderstood. Now, the threshold requirement is something that you have to meet even before you consider getting to what I will call the hard part of national interest waiver. So the the national interest waiver falls under the EB2 category. So employment-based green cards are broken out into 5 different categories, EB1 through EB5. EB2 is a category that applies to national interest waiver, but also when a company wants to sponsor someone for a green card. So when someone is applying under the EB2 category, they first have to meet the threshold requirement. So this is something you do before you even get into the national interest waiver requirements. You have to first meet the threshold requirements. And that is, you have to either have an advanced degree, so that's a master's degree or higher, or you have, so PhD or master's degree, that would qualify, or the equivalent, which is a bachelor's degree plus 5 years of work experience. Or you have to have, so let's say someone just has a high school degree, you have to have exceptional ability. And what you have to do is meet at least 3 of the 7 criteria that are listed on the slide. So that is something, again, that you have to do even before you get into the more difficult criteria related to national interest waiver. But again, sometimes people will contact us and they say, hey, I meet 3 of the 7 exceptional ability criterias, and they're not that difficult. They're not overly difficult to meet. Like one of them, for example, is just having any degree. But that's as I said, that just really gets you into the step 1 with respect to national interest waiver. So then we move in the next slide. We're going to talk about this in more detail. We move to the 3 main criteria related to national interest waiver. So once you've met these threshold requirement, and you only have to meet one of them. So if you have a master's degree, you're done. If you have a PhD, you're done. If you have a bachelor's plus 5 years experience, you're done. You don't have to then go ahead and meet the other exceptional ability criteria. That's just one of them is fine. So then we look at the national interest waiver requirements, and they are based on a case. The case name is Vanisar, and it's a 3-prong test. And the first prong in that test is the applicant's proposed endeavor has substantial merit and national importance. So that really is saying that what the applicant is, what it is that the person is coming to the United States to do has either substantial merit or national importance. And substantial merit typically is relatively straightforward to meet that requirement. but there is an and there rather than or. And national importance is the one that is very, very difficult because that often has to do with the nature of the endeavor being significant enough to be that it's in the national interest, and they want to give you a green card as a result of that. And step one, the first step that you're always going to do with a national interest waiver petition, the applicant has to define what it is that they're coming to the United States to do. So what is the endeavor? That's the first thing that has to be done. And that's not something that your attorney can do for you. It's you have to be able to articulate what it is that you're coming to the United States to do, because the whole petition is going to be based around that. It's going to be based around the endeavor and what it is that you're coming to the United States to do. And then when you look at that, when you look at what is it the person's coming to the United States to do, then the government's going to assess whether or not that particular endeavor has substantial merit and national importance. So you could be an entrepreneur, and you could be an entrepreneur that, job creation could be the national importance, in particular if the jobs are located in economically depressed areas. It could be that you've invented something, and that could be nationally important. Often when we're looking at the endeavor, we're looking at what is the problem and how is what you're going to do going to solve that. And then the problem, of course, has to be of national importance. We've done national interest waivers for people who are cybersecurity experts. We've done national interest waivers for people who are coming to the United States to assist with counterterrorism. And keep in mind that national interest waiver, the endeavor is not a profession, right? You can't just say, okay, well, I'm going to be an airline pilot, or I'm going to be a cybersecurity person. That can never be the endeavor. The endeavor has to be specifically what it is you plan on doing and what it is you plan on accomplishing while you're actually in the United States. The second prong in DANISAR, it has to do with the applicant is well positioned to advance the endeavor. Now, this one is one that sounds like it would be easy to obtain, but it's a lot more difficult. So we're going to look here at the person's background. We're going to look at their experience, their education requirement, their educational accomplishments, and that's going to be important. But one of the very, very significant things with this is the track record. And the person's done it before, maybe in their home country. And the key thing to look at here is when you're looking at the person's well positioned to advance the endeavor, it's the endeavor that they talked about in point one. That's what's going to be important here, right? Because it can't just be any endeavor. It has to be like, if you say that you're going to open up 10 locations and hire 200 employees, then that's the endeavor that you have to be well positioned to advance. If you say that you're going to open up a consulting company that's going to provide cybersecurity guidance for multinational corporations and government, then that's the endeavor that you have to show that you're well positioned to advance. So track record of doing it in the past is going to be important. And then sometimes how far along the endeavor is. If your national interest waiver has to do with being an entrepreneur, then maybe you want to show that you've been accepted into some incubator, or you want to show that you have been capitalized the company, or you've obtained investments. It could be that this particular category is demonstrated by patents or other things that you have accomplished, or in other intellectual property. But that's how that's going to look. So on the next criteria is on balance, the government should waive the labor certification. So the national interest waiver, what is being waived is the labor certification. So the government has said is that it's in the national job protection is in the protection of U.S. jobs is in the national interest. So what this particular criterion is getting at is that you're looking at whether or not the government should waive the labor certification. And what that is going to do is look at, on balance, they're going to look at the positive and negative factors and make a determination. And a lot of the time here, what we're going to do is apply sometimes the extraordinary ability considerations that you see in the EB1 context to say that this person is so fantastic and so extraordinary that you should waive the labor certification. Sometimes you're going to look at the evidence in prong one and prong two, because if something is nationally important, you can use that as the argument, or if the good things about the person's background, if they have great experience, if they went to great schools, et cetera, then you might be able to use that for why they should waive the labor certification. If the person is self-employed, then the person isn't eligible to be sponsored, so that we use that argument, and we've used that effectively for people as well. And the idea here is that the national interest waiver, like whatever the person is proposing, it doesn't have to ultimately lead to success, but it has to be. It's more likely than not that it's going to be that what they're doing is actually going to be successful. So when we look at national interest waivers, we consider a few things. So one, the national interest waiver is a very high bar. There definitely has been an increase in RFEs and denials on national interest waiver petitions, but that's why it makes it more important that you find someone who has done a lot of these petitions before. The timing, you can actually pay the government $2,800 for an adjudication in 45 business days. Regular processing can take a year or longer. If you do have an underlying visa, like we do a lot of E2 to NIW, H1B, TN to NIW, you do have to look at the type of visa that you're on. If you're on an H1B, it's not going to be a problem because that's a dual intent visa. But if you're in a TN or an E2 or E1, then you do have to really look at the timing and when you have to renew your visa, and you want to make sure that if you file the I-140, that possibly the petition is approved before you actually have to renew, because you could run into difficulties if it is not. In terms of the application process, you're going to submit an I-140 with proof that you meet the EB2 qualifications. It's quite a lengthy petition, usually hundreds of pages, sometimes 1,000 pages of documents. You normally will get expert opinion letters and a lot of different documentation to support the claim. And then if the category is current, then you're going to file an I-485 petition, and we're going to talk about that a little bit. So what happened right now, the category is not current. The EB2 category is not current, so there's about a 1.5 to 2 year wait, because the government can only issue a certain number of green cards each year by country. So you can get the I-140 approved and have it approved, but you may have to wait to get the green card. So you do have to look at the underlying status to be able to you have to make sure that you're maintaining your underlying status, so that you don't run into any difficulties. And then the other piece of the puzzle is whether or not you do adjustment status or consular processing. So when the category is current, you're either going to do adjustment status in the United States or consular processing. That's really going to depend on your goals. If you do an adjustment status, there's going to be a period of time where you're unable to travel. So that's something to keep in mind. There was updated guidance in 2022. In all honesty, this might change because the new administration may come in and modify some of this. So there was guidance that kind of pointed to people in STEM fields and the benefit with respect to that. There's guidance with respect to entrepreneurs. And here's some things listed here of things that might support a petition for an entrepreneur, like for example, media attention related to the petitioner, awards, the grants. We talked about like if they have a patent or something like that, if they have investment from venture capital, we talked about that. Anything like letters from government agencies, and we're going to talk about a case where there were a lot of those types of letters that were very helpful, and evidence that the company actually has been able to generate revenues. That's going to be important as well. They show that they're well positioned. Some of these things we talked about. We talked about the degrees, like your education, your work experience, and really things that are going to show that you are moving or have moved very close to actually obtaining the end goal with respect to your endeavor. So in terms of what is included in the NIW submission, so first, proof that you've met the threshold requirements, right? So if you're bachelor's plus 5 years, you're going to give your bachelor's degree plus letters that show that you have 5 years work experience. The other proof is going to be that you meet the actual 3 criterion. So one, that the endeavor is in the national interest. You always have a proposed endeavor statement that you're going to utilize, and that's going to be used to show exactly what it is you're coming to the U.S. to do. You're going to show that you may show there might be academic papers, there may be other documentation from the government that says that they feel that this particular area is important and something that's beneficial to the United States. It could be that you're going to have a business plan that is going to show, employees that you're going to hire, or the benefits of your business. One key thing in national interest waiver petitions are expert letters. So the expert letters are used to demonstrate substantial, merit and national importance. So they might be describing why something is actually important. They could also be describing what you have done in the past and why you're well positioned to do it in the future. And then you're going to include all the other relevant information for the three prongs, like maybe the degrees. If you're saying that the person has a patent, you include information related to the patent. If you're saying that the person has extraordinary ability for the third prong, you're going to include information related to that as well. So really, the applications are quite voluminous. So this short case study, I'm just going to go over briefly, and it's one that I really like because it's an entrepreneur, and the person obtained an NIW. And now this is an interesting case because initially when the petition was filed, the case was denied. Because the reason this case is important is because it is an appeals case, and the appeals case is one that, because it's an appeals case, and the appeals case is one that is used in a lot of cases especially when we're doing cases for entrepreneurs. The applicant was an entrepreneur. It formed a small consulting company. The case says many times it was a small consulting firm to work on projects focused on improving services to U.S. veterans. And they showed that there were expert letters that showed that this was important. There were articles, news articles, there were government reports that showed this. And the government ultimately concluded, or the appeals board ultimately concluded, that this was sufficient. They showed that the person provided letters from government and other businesses, showing that he was able to do things like this in the past, maybe in his home country. He had a business plan that pointed out what he was going to do. He had prospective clients. He had a marketing strategy, emails and letters from prospective clients. All of those were helpful in proving prong number 2. And on balance, because he was an entrepreneur, he was able to show that he couldn't sponsor himself for a green card anyway. So this is something that on balance, that criteria really wasn't that applicable for entrepreneurs. But then he also pointed to other things in prong 1 and 2 that made his case more effective. So this was ultimately approved. So that was really all the prepared remarks that we have for the National Interest Waiver webinar today. Definitely, we just touched the surface on these. If you have additional questions related to your specific case, we encourage you to set up a consultation, and we'd be happy to walk through the NIW requirements and also take a look to see whether or not you are eligible for the NIW. We do a lot of NIW cases, and we move people from other visas often to NIW, E2, H1B, etc., to National Interest Waiver, because it is a good option for a green card. I'm looking to see if there are any questions. I don't see any. It doesn't look like anyone has. I'm just looking here, Q&A. No, I don't see any questions here. So thank you very much for joining, everyone. And as I said, we will send you information, the presentation, the link to set up a consultation, the link to see this video again on our website, and a guide. Thank you very much again.